Like,
Good on the pronunciation of it.
The Subcommittee on Health, Employment, Labor, and Pensions will come to order. I note that a quorum is present. Without objection, the chair is authorized to call a recess at any time. Judging by recent events, President Biden is making good on his promise to be the most pro-union president, leading the most pro-union administration in American history. When President Biden joined the United Auto Workers picket line in Michigan last September, he put his thumb on the scale in favor of the union like no president has ever done before. Ironically, President Biden claimed to stand with the workers who are directly hurt by the Biden inflation and the America Last energy policies that are so harmful to that very auto industry. Biden's federal bureaucrats regularly fall in line to promote union interests over workers and job creators. But the National Labor Relations Act does not play favorites between unions and businesses. The NLRA has two basic functions. First, to determine whether employees wish to join a union, and second, to prevent and remedy unlawful actions of employers and unions. The U.S. Supreme Court recognized in Letter Carriers v. Austin in 1974 that federal law favors, quote, uninhibited, robust, and wide open debate, end quote, between union and management. The law provides a level playing field for workers to decide whether to join a union and protect workers who decide to work for themselves. But somehow President Biden didn't seem to get the memo. The Biden administration is attempting to micromanage every employer-employee relationship in the country at the behest of big labor union bosses. To achieve its goals, the Biden administration has weaponized the anti-business National Labor Relations Board to target business owners across America. The NLRB serves as the pro-union litigation arm of the Biden administration. To this end, it targets job creators, adds burdensome red tape for small business owners, and severely reduces employee free choice. In two recent board decisions, the NLRB drastically overstepped its mandate. In the Cemex case, it limited the longstanding right of employees to vote in secret ballot elections. Additionally, the board decided that a union could simply claim majority support through the unreliable card check process. This makes it easier to impose union representation on workers and businesses. The Atlanta Opera decision further curtailed employee rights when it revived the Obama-era standard for determining independent contractor status. Some estimate that over 60 million workers across the U.S. enjoy independent contractor status and the freedom that self-employment brings. This disastrous decision by the NLRB will crush their ability to earn a living as they choose. Finally, the NLRB issued a final rule that undermines the franchise model for many beloved brands that Americans know and rely on. Franchisors or franchisees like 7-Eleven, Dunkin', and Great Clips are major economic actors comprising 11.4% of all businesses in America. One estimate found that a similar NLRB rule during the Obama administration would have cost the franchise model $33.3 billion annually and cut 376,000 jobs. This is the promise of a pro-union president. Businesses will suffer and American workers will lose their jobs. Republicans, on the other hand, side with employees who value their precious right to join, or just as importantly, not to join a union. The legislation we'll consider today, the Employee Rights Act, Save Local Businesses Act, Modern Work Empowerment Act, and Small Business Before Bureaucrats Act, are all proposals that will affirm employee rights, not union rights, and they'll fight back against the Biden administration's big labor agenda. Make no mistake, when Biden brags about being pro-union, he intends to line the pockets of union bosses and inflict pain on business owners and their employees. With that, I look forward to today's hearing, and I yield to the ranking member for an opening statement.
Thank you, Mr. Chairman. I want to thank all the witnesses. Protecting workers' rights to organize and confronting worker misclassification is crucial to ensuring workers succeed in the modern economy. As a former business owner, it's important that your workforce, whether they're unionized or not, are respected and have a voice for the success of the business. That's what the labor movement frequently does, often does, is helps a balance. When workers have the power to negotiate for higher wages, better benefits, and safer workplaces, we all share in those victories. As members of this committee, we are charged with empowering workers. Instead, today, we are meeting to push bills that favor wealthy special interests at the expense, all too often, of workers' rights. We cannot forget that workers in the labor movement built the middle class by giving employees a voice on the job. And some of our nation's greatest advances stem from workers having a fair share of the profits that they help create. The American people's support for unions has never been higher. Unlike on many issues facing this country right now, Americans across party lines are united in support of the labor movement's goals, according to a recent poll from Navigator Research. Just last week, for the first time in Louisiana history, nurses at the University Medical Center, New Orleans, voted overwhelmingly to unionize, and many of them said they were inspired by the UAW's successful contract with Detroit automakers. They see the best impacts of union representation coming from better pay, more benefits, and stronger job security. Unfortunately, after reviewing the three bills discussed today, the Modern Worker Empowerment Act, Save Local Business Act, and Employee Rights Act, it is clear these bills do not share the same goal of supporting workers' rights to form a union. These bills limit workers' rights and protections by chipping away at the Fair Labor Standards Act and the National Labor Relations Act. Democratic committee staff was initially told that H.R. 3400, the so-called Small Business Before Bureaucrats Act, would be part of today's legislative hearing and our witnesses. Mr. Griffin commented on it in his written testimony. I am disappointed that the committee, my friends on the Republican side, opted to instead mark up this bill yesterday and bypass this hearing. The agenda of today's hearing is also particularly troubling, considering that the rise of aggressive union-busting campaigns and worker misclassification by unscrupulous employers, not all employers, unscrupulous employers, between 2016 and 2021 alone, more than 85% of employers conducted anti-union campaigns during union elections, including firing organizers, closing stores, and reducing pay. Further, the misclassification of workers allows employers to cut corners and skimp on worker pay. Again, not all employers. Some employers make it more difficult for employers who respect their workforce, leaving taxpayers to foot the bill for lost tax revenue caused by misclassification. Thankfully, under President Biden, the National Labor Relations Board has taken key steps to hold bad actor employers accountable for violating workers' rights and undo the dangerous precedents set by the board under the previous administration. For instance, the board restored the long-standing process for determining whether a bargaining unit is appropriate, after the Trump administration made it easier for employers to gerrymander elections against the workers and unions. Lastly, NLRB General Counsel is undertaking a historic effort to restore labor law's promise of full freedom of association. This includes ending the practice of captive audience meetings, where employers force workers to listen to anti-union propaganda or else face discipline and termination. But ultimately, the responsibility of protecting workers' rights also falls on us, Congress. That is why we must pass legislation that improves the lives of workers and their families while also boosting our economy and helping responsible employers. For example, the Protecting the Right to Organize Act, the PRO Act, levels the playing field for workers and strengthens their ability to form unions to bargain for higher pay, better benefits, and safer workplaces without the fear of intimidation or retaliation. We should also advance the Wage Theft Prevention and Wage Recovery Act, which deters wage theft practices and helps workers recover lost wages. Finally, I hope my colleagues will help us finally put an end to child labor. The Fair Labor Standards Act was written with a broad definition of employment precisely because too many businesses, exploited narrow definitions to turn a blind eye to child labor violations. The bills that are the subject of the hearing today would turn back the clock on child labor at a time when violations are on the rise. In contrast, the Democrats' Protecting Children Act would provide federal worker protection agencies with the resources they need to deter violations and protect children from being forced to work in dangerous working conditions where they may be injured. In conclusion, workers are counting on us to stand up for them. The last thing they need or want is for us to chip away at essential worker protections. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. DeSaulnier. And pursuant to Committee Rule 8C, all members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5:00 p.m., 14 days after the date of this hearing, which is December 27, 2023. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. And I will now turn to the introduction of our distinguished witnesses. Our first witness is Mr. Roger King, who is the Senior Labor and Employment Counsel at the HR Policy Association in Washington, D.C. Welcome, Mr. King. Our second witness is Mr. Matthew Howler, who's the President and CEO of the International Franchise Association located in Washington, D.C. Welcome, Mr. Howler. Our third witness is Mr. Richard Griffin, who is of counsel to the firm Bredhoff and Kaiser, which is located in Washington, D.C. Welcome, Mr. Griffin. And our final witness is Mr. Vincent Vernuccio, who's the president and co-founder of the Institute for the American Worker, which is located in Hamilton, Virginia. Welcome, Mr. Vernuccio. We thank all the witnesses for being here today. We look forward to your respective testimonies. Pursuant to committee rules, I would ask that you each limit your oral presentation to a 5-minute summary of your written statements. And I'd like to also remind the witnesses to be aware of the responsibility to provide accurate information to the subcommittee. And with that, I'd like to first recognize Mr. King for 5 minutes.
Chair Good, Ranking Minority Member DeSaulnier, and Mr. Scott, I also see you in attendance. It's nice to see you again. Thank you for another opportunity to testify before this committee. As noted, I serve as the Senior Labor and Employment Counsel for the HR Policy Association. The association represents approximately 10% of the private sector workforce in the country. Over 10 million employees work for members of our association. We regularly interact with the Congress and executive agencies on employment and labor law matters, so we welcome this opportunity this morning. I want to emphasize 4 points in my testimony at the beginning of our discussion today. First, the National Labor Relations Board statutorily is to have 5 members. It has only 4 members. It's had 3 Democrat members and only 1 Republican member now for almost a year. Indeed, on December 16, it will be a year that the Republican seat has remained vacant. The White House has been totally silent on a nominee for this Republican vacancy. Despite inquiries, our association has received no response. Correspondingly, when a Democrat vacancy occurred earlier this year, the president moved expeditiously, and the Senate moved also expeditiously. That Democrat seat was filled in 14 days. So we have a contrast of a year vacancy plus and 14 days. That has adverse consequences on policy decision-making at the board. When former member John Ring's term expired December 16 last year, his staff went to the 3 Democrat members. So at present, there are approximately 50 staff attorneys, 50 staff attorneys working for the 3 Democrat members and only 12 for the lone Republican on the board. That certainly provides a significant advantage for the Democrat members in research and writing and puts undue pressure on the lone Republican member, although Member Kaplan's done an excellent job. Second, because there's not another Republican on the board, a second Republican, as there has been by tradition, the board decides cases on a 3-member panel basis, so mathematically, you can never have a Republican majority on a 3-member panel given the current composition. And third, and perhaps most importantly, the diversity or lack thereof of opinions in the board's decision-making which, Chair Good, I certainly agree with you, has been quite imbalanced. Every major policy decision issued by this board has been unfavorable to employers and employees. This needs to be corrected, and hopefully this committee can make inquiries of the White House to determine exactly when this vacancy will be filled. In my testimony, I have a suggestion I think could receive bipartisan support. When a board member's term expires, that individual would continue to serve until she or he was replaced or renominated. There are a number of executive agencies, Federal Mediation Board being one, that have that type of process. We've had way too many vacancies over the years in both Republican and Democrat administrations. The vacancy on the board issue needs to be addressed. Second, the board's credibility is entirely lacking at this point. As I note in my written testimony, over the last 15 years, the National Labor Relations Board has reversed precedent in 4,660 cases. 4760. How can any business, any union, any group of employees keep up with the constant change of the law? Illustrative of this fact, the Biden board, just in the last few months, has reversed 124 years of precedent. There's been no study that contradicts these figures. I know Mr. Griffin may not agree with them, but there's been absolutely no study that has come forward to contradict these figures. This agency is a perfect example of the executive branch being out of control. Executive agencies owes the Congress responsibility and owes stakeholders, the general public, a duty to conduct its business much more efficiently and fairly. That's not happening. The NLRB has become Exhibit A of why the courts should roll back or curtail the degree of deference given to executive agencies. And my final point on this issue is small and independent businesses cannot keep up with this constant change.
I've given you an extra 30 seconds there. Your time's expired, so I'm going to have to.
And I will wrap up.
But hopefully you'll be able to make that point during the questioning period with one of our members. Now recognize Mr. Howler for 5 minutes.
Chairman Good, Ranking Member DeSaulnier, distinguished members of the subcommittee. My name is Matt Howler. I'm the president and CEO of the International Franchise Association. Today, there are more than 3,000 franchise brands and nearly 800,000 U.S. franchise locations, employing more than 8 million workers. Franchising is not an industry, nor is it a way, as some contend, to shirk responsibility for employees or avoid unionization. Rather, franchising is a business model that allows brands or franchisors to license their concepts to individual business owners or franchisees. Brands use the franchise business model to reach new markets more quickly, delivering products or services consumers desire. In doing so, franchising democratizes wealth creation by enabling individuals to build the American dream of small business ownership at the local level, not simply enriching corporations and shareholders. In franchising, we say you go into business for yourself, but not by yourself. Franchising is an opportunity for someone to join a system and learn how to be a successful small business owner. In fact, IFA research reveals 1/3 of franchisees say they would not own a business without the support of the franchise model. The use of franchising is wide and varied throughout the economy, from hotels to gyms to early childhood education and pet services. Franchising is in more than 300 industries and growing. Franchising is not big business. Franchising is small business. More than 80% of franchise owners operate a single location. And more than 50% of franchisors have fewer than 20 overall locations. Congress recognized this fact when it passed the bipartisan Paycheck Protection Program that saved tens of thousands of franchises during the pandemic, classifying franchisees as the small businesses that they are. Franchising has nearly double the rate of business ownership among minorities and higher rates of ownership by women and veterans than non-franchise businesses. Franchises offer countless opportunities for employees to become business owners. For example, more than 95% of Domino's franchisees started as part-time pizza makers or delivery drivers. In most companies, employees can't own the business. But in franchising, you can. It's the difference between working at a Starbucks and a Dunkin'. Starbucks is just one corporation. But at Dunkin', which has more than 9,000 US franchise locations, an employee often works their way up and can own their own store. Yet the NLRB's final joint employer rule threatens all of this. If you take one thing away from today, it should be this: Congress must stop the final joint employer rule to protect franchising. That is what is at stake here. We've seen this joint employer movie before, and we don't need a sequel. The last time the NLRB expanded the definition of joint employer, it cost franchises $33.3 billion per year, eliminated more than 300,000 jobs, and increased lawsuits by 93%. A survey of franchisees by Oxford Economics found an overwhelming number of franchisees fear the same consequences today. Only 14% of franchisees said they would definitively open a franchise if this rule were in effect. I commend Congress for taking swift action to address this issue, including the Save Local Business Act, sponsored by Congressman James Comer, and the Bipartisan Congressional Review Act resolution, proposed by Congressman John James, which this committee reported favorably yesterday. There is a broad-based coalition of more than 70 national organizations, and the impact goes far beyond franchising, including the American Trucking Associations and the American Hotel and Lodging Association, and more than 50 state organizations, from Montana to Maine, supporting these bills. The coalition also includes people like Tamara Kennedy, who used franchising to create the American dream. Tam started at an entry-level position at a Minnesota Taco John's and went on to buy 7 restaurants. And Courtney Escalante, a McDonald's owner-operator in California, who said the joint employer rule threatens to undermine our business's success and in turn irreparably harm our team members and local communities. For those defending this rule, I challenge you to think about how you will answer the questions from your constituents about how to comply, given the inherent ambiguity in the NLRB's new definition of what constitutes control. If you ask the NLRB for examples of indirect and reserved control, they have no answers. Franchise businesses thought the Browning-Ferris standard was as bad as joint employer policy could be. Yet somehow, the NLRB has created a policy that is even worse. The bottom line is Congress has a choice to make. Allow the NLRB to continue with its final rule that would upend franchising as we know it, or step in and preserve all the good that franchising has created for so many. Thank you again for the opportunity to testify. I look forward to the discussion.
Thank you, Mr. Haller. And we'll now recognize Mr. Griffin for 5 minutes.
Chairman Good, Ranking Member DeSagne, and members of the subcommittee, thank you for the opportunity to testify on the bills before you today. These bills would move national labor and economic policy in the wrong direction. I strongly urge you not to adopt them. I strongly urge you to adopt them. My name is Richard Griffin. I have practiced labor law for 42 years. I'm currently of counsel at the Washington, D.C. law firm of Bredoff and Kaiser. I previously served as a National Labor Relations Board member and as the agency's general counsel. My testimony today draws upon my varied experiences as a labor lawyer and is specifically informed by my NLRB tenure. I start by strongly affirming the central importance of workers' right to join together to form unions, to act together for their mutual aid and protection, and to bargain collectively. These rights are protected by the National Labor Relations Act, but often go unexercised out of fear or ignorance. As a result, the gap between what workers earn and what management takes home has grown ever wider, and our economic system fails those who do the real work of the enterprise. However, the bills before you will not work to workers' advantage or help the economy as a whole. Rather, these bills would strip many workers of fundamental protections, creating a group of second-class citizens. When so many workers are demanding their right to a union and a more just economy, today's hearing ignores those voices. My written testimony addresses all the problematic provisions of the 4 bills. I'll focus my testimony here on H.R. 2700, 2826, and 5513. H.R. 2700 is the most extensive and most troubling of the bills under consideration. It would do damage to many provisions of the National Labor Relations Act and the Fair Labor Standards Act. First, Contrary to years of precedent, it would eliminate voluntary recognition as a lawful means for unions to obtain exclusive representative status, thereby disrupting many existing voluntary agreements made by employers and unions. Second, it would limit the employee contact information employers are required to provide to unions during the NLRB representation election process and place limitations and penalties on the union's use of that contact information to communicate with employees. Employers already have a substantial election advantage because they can communicate throughout the workday with employees in the workplace, while under current precedent, unions are denied access to the workplace. The bill would make the board's election process more unfair. Third, H.R. 2700 would impose unprecedented and unconstitutional limitations on unions' use of member dues. Fourth, it would remove many employees from the overtime and minimum wage protections of the FLSA by applying the common law of agency employee definition to that statute, thereby opening the door to further exploitation of many of society's most vulnerable workers. Fifth, common to the common law right to control test, which allows for the consideration of both reserved and indirect control of employees' terms and conditions of employment, it would provide a narrow joint employer definition for both the NLRA and the FLSA and limit the factors that may be considered in making a franchisor-franchisee joint employer determination. This joint employer definition will allow large businesses like franchisors and users of temporary employees to escape responsibility for their involvement in determining employee terms and conditions of employment and leave small businesses like franchisees and subcontractors holding the bag. And sixth, H.R. 2700 would exclude tribal enterprises from NLRA jurisdiction, thereby depriving both tribal members and non-tribal members who work in tribal enterprises of their rights under the National Labor Relations Act. In sum, the bill is a collection of harmful changes and ill-considered policy. Turning to H.R. 286, that bill limits itself to adopting a narrow or standard for joint employer under the NLRA and FLSA and suffers from the same defect as H.R. 2700. The failure to allow for consideration under the common law right of control of reserved and indirect control, such that all of the entities that co-determine workers' terms and conditions of employment will not be at the bargaining table or responsible for payment of minimum wages and overtime. In order to conclude on a timely matter, I will address 5513 in response to the questions, but I urge you to reject these bad pieces of legislation, and I look forward to the opportunity to respond to questions. Thank you, Mr. Chairman.
Thank you, Mr. Griffin. And now we'll go to Mr. Vernuccio as our last witness for 5 minutes.
Mr. Chairman, Ranking Member, and members of the subcommittee, thank you for giving me the opportunity to testify here today. My name is Vincent Vernuccio, and I'm president of Institute for the American Worker. I4AW is a 501c3 nonprofit focused on educating about the benefits of freedom and collaboration between workers and job creators. I'm here to support the common sense policies that will empower workers and their families to rise and thrive in the 21st century. Congress has an opportunity to stand with workers by preserving the best of the status quo in labor policy, ensuring that tried and true worker protections and opportunities are maintained and standardized throughout the federal code, while taking small but impactful changes to advance worker self-determination. I will discuss 4 policies here today that put the individual worker at the center of labor law. They include the Employee Rights Act, the Save Local Business Act, the Modern Worker Empowerment Act, and the Small Business Before Bureaucrats Act. The legislation includes simple and narrow reforms that empower workers with more freedom and more flexibility. The ERA is about defending employee privacy and choice, in contrast to rules enacted by the NLRB and proposed provisions in the Protecting the Right to Organize Act. Card check is a mechanism of union organizing where a union collects cards to unionize employees. It bypasses the protections of a secret ballot election and can lead to coercion and deception of workers. The problems with card check in union organizing are well documented. In the past, this committee has heard from former union organizers who have testified about manipulating workers to get cards signed. NLRB cases show intimidation. A card solicitor allegedly told another employee that she had, quote, better get a card signed because if she did not, the union would come and get her children and slash her car tires. And card check intimidation is not just limited to employees. Unions go to great lengths to force companies to agree to card check by sophisticated anti-PR campaigns called corporate campaigns. These campaigns go after companies' reputation to try to drive away customers and harm their business. The goal is to have the company take away the secret ballot from their employees. The NLRB's CEMEX decision and the PRO Act allow for a backdoor version of card check, allowing employees to have the false notion of an election, then negating the vote and recognizing the unions by card signed if the employer violates labor law. Additionally, even with an election, unions are given unfettered access to employee personal information, such as their personal email, their cell phone, and their home address. Employees are not free to opt out of giving the union this information. There has been testimony of unions refusing to take no for an answer and harassing workers at home. This is why the ERA's secret ballot provision and its privacy protections, giving workers control over what information is given to a union, is needed. The ERA and the Modern Worker Empowerment Act also safeguard the choice of independent workers to work for themselves. This is needed as the Department of Labor, the NLRB, and the PRO Act are all attacking independent contracting by varying degrees. We have numerous stories on our website, i4aw.org, about entrepreneurs whose livelihoods have been shattered when the ability to freelance was attacked. The ERA and the Modern Worker Empowerment Act would defend independent contractors' ability to work for themselves or have side hustles by standardizing a common law test for who is an employee or giving more weight to entrepreneurial opportunity, respectively. The ERA and the Safe Local Business Act would defend small business and their employees from being forced to be subsumed into larger businesses. These are in response to efforts by the NLRB and provisions in the PRO Act to change the definition of who is a joint employer, something that before the Obama administration had been settled law for decades. The ERA would keep employees from subsidizing politics they disagree with. The ERA would give workers an annual opportunity to decide if they wanted to continue to fund union politics. And finally, the Small Business Before Bureaucrats Act would modernize the threshold of NLRB jurisdiction, essentially matching inflation to codify the standards of who the NLRB had jurisdiction over 65 years ago, the last time the thresholds were set forth. These reforms defend the best of current labor law while enacting simple yet powerful safeguards of worker rights. Workers deserve to make voluntary decisions about unionization, free from intimidation and harassment. They deserve to have their privacy protected and to work in a way that is best for themselves and their families. Thank you.
Thank you, Mr. Vernuccio. Under Committee Rule 9, we will now question witnesses under the 5-minute rule. I will wait to ask my questions and therefore recognize Chairman Fox for 5 minutes.
Thank you, Mr. Chairman. I want to thank our witnesses for being here today. Mr. King, in 2022, labor unions won 76.3% of representation elections. Despite labor unions' success in elections, the NLRB issued a decision in the CEMEX case that upends the current union representation framework by greatly diminishing workers' right to vote by secret ballot. Since unions already win most representation elections, it appears this decision is a solution in search of a problem. What is the NLRB's ultimate goal in issuing the CEMEX decision?
Thank you, and it's good to see you again. And I want to congratulate you and Mr. Scott on your leadership this year. This committee's been one of the most productive committees in the Congress, and
Thank you.
You've done great work. The NLRB is attempting to go to card recognition, taking secret ballots out of the equation. The secret ballot process by which members of this committee are elected, and the way we run our country, is under attack. And the CEMEX case is clearly wrong. It's going to be tested in the courts, and I think ultimately the NLRB position will not prevail.
Let me ask a quick follow-up. In your opinion, what are the reasons for the long-term decline in private sector union membership, which is now 6% of workers? Mr.
Well,
King?
there are so many different answers to the question. First of all, we have legislation at the state, local, and federal level that really make the union equation unwanted, unneeded. Second of all, workers want independence. Mr. Haller referenced the franchisee model. Workers, employees in this country want the flexibility to do as they please. They don't want to be dictated to. And finally, unions have lost their way, frankly. They aren't spending their resources on traditional organizing. They're spending on political activity. They're spending on contentious UAW strikes that make no sense.
I'm gonna get to some of that in a minute. Mr. Haller, from 2015 to 2020, the expanded joint employer standard from the board's Browning-Ferris decision cost franchise businesses an estimated $33.3 billion per year and prevented the creation of 376,000 jobs. It also led to a 93% increase in lawsuits against franchise businesses. The Biden NLRB recently resurrected the disastrous Browning-Ferris decision via a final rule published in October. What can Congress do to restore certainty for the franchise industry and support local business owners' ability to provide jobs for American workers?
Thank you, Chair Fox, for the question. Franchising is the American dream, and franchise businesses are always in a unique position to help address our economic challenges if government doesn't get in the way. And we applaud this committee for considering the Save Local Business Act, introduced by Congressman James Comer. The bill would codify the permanent joint employer standard based on direct and immediate control of the business, not a vague, unworkable standard as now proposed and finalized by the NLRB. The Save Local Business Act is also part of Congressman Rick Allen's Employee Rights Act, another topic of today's hearing. IFA is proud to support both, as well as the Congressional Review Act challenge proposed by Congressman John James, which this committee reported favorably yesterday. Any of these would protect the franchise business model from the NLRB's harmful joint employer rule.
Thank you. Mr. Vernuccio, labor unions have become highly political. In the 2022 election cycle, organized labor spent more than $1.67 billion on political activity and lobbying, according to a report from the National Institute for Labor Relations Research. The overwhelming majority of big labor political spending goes to progressive causes and politicians. Do all workers represented by unions support union political spending and statements that promote progressive causes and politicians?
Thank you for the question, and the fast answer is no. 40% of union members, survey after survey of union households, typically vote Republican, and it does not stop, the union politics does not stop with direct candidate giving. We have seen statements from unions, unfortunately recently, supporting things like Palestine against Israel. Right after the October attacks, a Starbucks Workers United post on Twitter put solidarity with Palestine in front of a picture of a bulldozer. There was an NYU UAW local that said that this past weekend's events did not occur in a vacuum, nor were they unprovoked. We hold Israeli regime and its apartheid laws responsible for the painful death and destruction and despair of this past weekend. So it's not just political giving that, unfortunately, these unions are advocating.
Thank you again to our witnesses, and thank you, Mr. Chairman.
Thank you, Ms. Fox. And now we'll recognize my distinguished friend from Virginia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Mr. King, you were cut off in your testimony. Did you want to make one last point before we get started with questions?
I beg your pardon?
You were cut off on your testimony.
I just had one additional point. Yes, thank you, Mr. Scott. The union movement in this country is sitting on approximately $40 billion of assets. But yet the data shows it's not spending those resources for traditional union organizing. And I think it's a fair question to ask why not. And the final point I wanted to make, Mr. Scott, was when you look at the number of eligible members in the private sector to become under a union contracted member, the union movement's only attempting to organize less than 0.1%. So those are fair questions, I think, to ask why the PRO Act is even needed. Thank you for your courtesy.
Thank you. Mr. Vernuccio, you indicated that you answered the question, union had given so much to political campaigns. Do you know how much businesses are given to political campaigns? And do shareholders have a say in where that money goes?
I believe if you look it up, you see generally semi-even splits between both political parties and causes between business giving. Unfortunately, and I think the point that Chairman Fox was trying to make is that the overwhelming majority of political giving of unions goes to one side of the aisle or one point of view, while their membership, about 40%, may disagree with that.
And you're saying business splits their contributions equally, but shareholders don't get a say on where that money goes. Is that right?
I believe businesses split it quite a bit more than unions split their political giving. If you look at election reports,
It was basically a rhetorical question anyway. Mr. Griffin, question was made in changing precedent on the joint employer rule. Was precedent changed or restored in the Biden joint employment rule?
Well, the precedent for many years prior to the TLI and Laerco cases took into account reserved control and indirect control. That was for the period up until the mid-'80s. Then there was this imposition of a requirement for direct and immediate control without indicating that there was any overruling of precedent. And when the board looked in the Browning-Ferris case, when the general counsel's brief, for example, urged the board to return to restore the original understanding of the common law. So the short answer to your question is it's a restoration of precedent, not an overturning.
Thank you. And on the franchise situation, if the franchisor requires, say, that pay can't go over $15 an hour, but otherwise doesn't do anything, and if you don't have the joint employment rule and the franchisee is the only, quote, employer, what good does it do to try to negotiate wages when it's already been set before the franchisee can have a say?
Well, the whole purpose, to your point, the whole purpose of the joint employer rule is to make sure that the entity that controls terms and conditions of employment is at the bargaining table. And that doesn't mean they have to be physically present. They certainly, as in many multi-employer situations, can designate a common agent to negotiate on behalf of both the franchisee and the franchisor. But if the franchisor does have control over terms and conditions of employment, they ought to be at the bargaining table, because otherwise the collective bargaining over that particular term and condition is going to be useless with the franchisee because they don't have discretion.
Thank you. Today, if a company illegally fired someone for organizing a union, clearly an unfair labor practice, what happens?
The individual or someone on the individual's behalf would file a charge with the NLRB. The NLRB regional office would investigate the charge, and if there was merit found and the case wasn't settled, the complaint would issue. The matter would be tried before an administrative law judge. The administrative law judge would issue a decision. That decision would be subject to appeal to the NLRB itself in Washington, and then that decision, if it found a violation, would be subject to review in the circuit courts of appeals.
And then how long does that take, and what does the employee get at the end?
It very much depends on the circumstances. It could take a very long time because of if you go through all the steps in that process, including going up to the Court of Appeals. Sometimes it takes as long as a year or 2 years after the board's decision for the Court of Appeals to have the case briefed, argued, and decided. So it could take several years. At the end, the employee gets back pay minus interim earnings and reinstatement.
So if they wouldn't got a job at a better
Gentleman's
place,
time has expired.
there would be no compensation, is that right?
That would be counted against them. They wouldn't get compensation. That's correct.
Thank you, Mr. Scott. And now we'll recognize Mr. Wahlberg from Michigan for 5 minutes.
Here we go again. This morning, as we deal with this issue, it reminds me of the Groundhog Day movie, or Yogi Berra's Deja Vu all over again. This goes on, and it's frustrating because it's, again, a clear evidence that the union wants wants to put the thumb on the scale, is they can't accomplish it themselves. I'm not against unions, but franchises are successful because of choice. When you stop and think about it, 800,000 franchises in this country, and maybe more, that's what we're told. Thousands of those are owned by former employees who worked their way up, who aren't asking to be controlled by a union, but to have the freedom to be a franchisee. And so here we go again with the efforts to change what is working. Why? Because union wants to be big business, as opposed to helping little people, as they are often called. I call them free people making their own decisions, entrepreneurs who have a design that they can work with and they can be successful and they can help other people be successful as well. So it is frustrating, and I want to keep my record of not being bombastic, but this does frustrate me. In September, I, along with 80 of my colleagues, sent a bipartisan letter to the FTC on the importance of this rule, that being the FTC franchise rule, stressing that any future changes continue to support the future sustainability of the franchise model. Mr. Haller, can you please tell us about the FTC franchise rule and how it would continue to foster small business creation in the franchise space?
Thank you, Mr. Wahlberg, for your question, and also thank you for your bipartisan leadership on that issue. The FTC's franchise rule has served as an important tool to require franchisors to provide an extensive pre-sale disclosure document to prospective franchisees. That policy decision to favor pre-sale disclosure instead of rigidly prescriptive regulation has led the franchise sector to flourish, with thousands of franchise companies in more than 300 business sectors. Franchising has also provided an opportunity for countless veterans, minorities, women, immigrants, a pathway to wealth creation for their families, workers, and local communities. So thank you for your efforts leading this letter, along with your colleagues, Ms. Lesko, Mr. McGarvey, and Mr. Carter, along with many others in the House and the Senate. If I also may, I did want to take one moment to address the point that Mr. Scott made. There are no franchisors that set wages for franchisees' employees. And if they do, they should be held accountable under a direct control standard.
Right.
But that is not what we're facing here with the NLRB's joint employer rule. We are facing a much more expanded standard that, as I mentioned in my testimony, the NLRB has not been able to define.
Okay. Well, I appreciate you responding to that. Like all sectors of the economy dealing with Bidenomics, franchise businesses are navigating economic headwinds such as high inflation, labor shortages, and supply chain disruptions. Despite these challenges, the Franchise Business Review reported that franchisee satisfaction is at an all-time high, probably because they control their life to some degree. In your view, what's the biggest threat to the franchise business model, besides just government?
Well, government generally, but specifically today, this greatly expanded joint employer rule that goes into effect in February. 87% of franchisees are concerned about this because they don't want a franchisor coming in taking more control over their business. Alternatively, 82% of franchisees are concerned about reduced franchisor support. Either one of these outcomes is not good. As I mentioned in my testimony, only 14% of franchisees said they would definitively open a franchise if this rule were in effect. That is 800,000 businesses. And IFA represents franchising. We represent franchisors and franchisees. But groups representing all sorts of industries, including franchisee groups, also strongly oppose this rule.
Okay. Well, I see my time is about to expire. I want to ask a question, but I won't, Mr. Chairman, so I yield back.
Thank you, Mr. Wahlberg. We will now recognize Mr. Courtney from Oregon for 5 minutes.
Thank you. Actually, the state of Connecticut's a little bit, far away from Oregon, so
Apologies that it was told Oregon.
Red Sox Nation is where
Oregon,
I'm from. Actually.
Connecticut, what, 3,000 miles? I mean,
That's right. Yep. So I'm going to reclaim my 15 seconds I just gave up there, the geography lesson. Again, this is deja vu all over again. I agree with my friend from Minnesota, Michigan, Tim Wahlberg, that we're again talking about another set of bills before the subcommittee that are headed for the shredder and that are really aimed at doing nothing more than curtailing union rights at a time when, as I mentioned last hearing, the Gallup poll, which is conducted every year on approval of unions, again, is well above the norm, 67%. It dipped a little bit from last year, which was pointed out at the last hearing. But I did get some of the crosstabs, and they actually asked about the recent strikes that occurred with the United Auto Workers and the film and screenwriters. In the case of the UAW strike, over 70% of the respondents supported the union, only about 19% supported the company, and those were basically the same figures for the screenwriters. So we're at a point right now where, again, actually the American public has shown that they actually approve of unions and also think they're good for the economy. We saw this recently in southeastern Connecticut when Metal Trades Council just signed an agreement with General Dynamics Electric Boat for an over 20% wage increase. It's a 5-year contract. The CEO commented afterwards that this contract is a key element of our strategy to rapidly grow our production rate to deliver more submarines faster to the U.S. Navy, showing that collective bargaining can be good for not only workers, but good for business and good for our national security. Again, because the demand signal from the Navy for those platforms is off the charts right now. So, again, Mr. Griffin, this package of proposals in sum, really is just about suppressing union membership. And again, what's your perspective in terms of what does that mean in terms of our economy getting, again, the middle class where they need to be at a time when cost of living is high?
Well, I think your point is 100% correct that the increases in wages, the increases in benefits, the health and safety protections, the protection from discharge not for just cause, all the parts of a collective bargaining agreement are what allow people to become members of the middle class, what allow people to have safety on the job, have protection on the job from unjust dismissal, and allow for them to have retirement security, job training. These kinds of things come with a collective bargaining agreement. And it's not just for the people that are represented by the union. The first thing that happened after the UAW settled those contracts was a number of non-union car manufacturers raised wages substantially in response to the wage increase that was achieved in the collective bargaining agreement. So that's the ripple effect. That's the union raise for non-union workers, and that's all good for employees, for workers, and for the economy.
One other aspect, and we again see it down at EB, is that the Union Management Fitzgerald Act apprenticeship programs, which again is the earn while you learn for people, that gives now really hundreds and really in the coming years thousands of people an avenue to get a good skill that's going to be comparable to what you could get with a higher education degree. And again, that union collaboration is key to making sure that skilling up actually succeeds.
Well, you're kind of in my wheelhouse here because I worked for 28 years for a construction union that represented heavy equipment operators. And there's almost no way that an individual employer, because of the capital expense in heavy equipment, there's no way an individual employer can train heavy equipment operators. You have to do it jointly, collaboratively on a multi-employer basis. And that's what the joint apprenticeship and training programs provide. They also provide journey person upgrading, which allows you to get additional skills so you're more employable in the course of your work life.
One last thing on the provision in one of the bills here, which limits the way people can be communicated or contacted by unions. Again, just two quick questions. Number one, that doesn't apply to employers, correct? And number two, coming from a body where we contact people by text, by email, by mail, if you really care about elections and free choice, you need to, again, be able to have an opportunity to communicate with people. Isn't that correct?
Yes, you need a level playing field. The employer has access all day long in the workplace. The union is not allowed access to the workplace, so these bills will only exacerbate that problem.
Thank you. We will now recognize Mr. Allen from Georgia for 5 minutes.
Thank you, Mr. Chairman, and I want to thank our guest here this morning, witnesses, for your testimony. Obviously, we're in a different world today. It's changing rapidly. It's changing drastically in my 40-year business career. And in fact, when I talk to heads of unions, the biggest problem they have is recruiting a workforce, which is the biggest problem we have as employers, is recruiting a workforce. And so there's tremendous competition for workforce out there today. When I started in business, people were standing in line for a job. And I'm talking union people were standing in line for a job. In fact, we would hire groups, and then if they didn't perform, we would send them back and get somebody else. I mean, it was, you always had several people there standing in line. That is not the case today. And of course, the franchise model has created tremendous wealth. In fact, in my experience in business, where we self-perform most of the work initially in the construction industry, now we subcontract 95% of the work to union members who are now entrepreneurs running their own businesses. Every one of them came up through some type of apprenticeship program. So they're not liberal arts graduates. They came up through the apprenticeship program, and they're entrepreneurs, and they're doing quite well. Mr. Haller, as you're well aware, the Biden Department of Labor is currently seeking to finalize an unclear and overly restrictive independent contractor rule that would make it significantly more difficult for individuals to work as independent contractors. And it would have a devastating impact on millions of workers and thousands of businesses. Additionally, we've talked about this, the radical NLRB has recently finalized a rule to adopt a more expansive definition of joint employment. How would the independent contracting and joint employment provisions of, you had mentioned the Employee Rights Act, which we authored, impact the ability of American entrepreneurs and workers to climb the socioeconomic ladder?
Thank you, Mr. Allen, for the question, and thank you for your leadership on the Employee Rights Act. As you mentioned, the provision in that legislation that we strongly support would allow for franchising to continue to thrive. And we have countless stories in franchising where workers have gone on to eventually become franchise owners themselves. And our issue with this discussion and these issues is really not with unionizing. You can have collective bargaining, but you can also, without having a broad joint employer standard, right? You just can't have joint employer and franchising. They cannot coexist. The joint employer provision in the Employee Rights Act would allow people like Tam Kennedy, who I talked about in my testimony, and countless others, to go from the entry level to become franchise business owners and get that support that franchisees say that they need from the franchisor to become and stay successful small business owners. We appreciate your leadership and the committee's leadership on that issue.
Mr. Vernuccio, did I pronounce that correctly? Close.
You did. Thank you.
Good. All right. In August, President Biden's NLRB gutted workers' rights to decide union representation by secret ballot vote by issuing a decision to make it easier to conduct card-check union campaigns. Do you think card-check elections create an unfair election environment?
Thank you for the question, Mr. Allen, and thank you for your leadership on the Employee Rights Act. To answer your question, no, because there is no election environment. Card check bypasses an election and allows for unions to have an open, basically, petition process. Unfortunately, with the PROAC and with the CEMEX decision, unions still can tell employees you will have an election, but then the rug is pulled out from under the workers. And even though they have an election, unions can say, well, there was an unfair labor practice or the employer violated a portion of election law, and say recognize us via cards. And with the new CEMEX decision, the NLRB could then recognize the union. This is why your provision in the Employee Rights Act is so important.
Yeah, and the secret ballot is a long-time important tool in our culture. And As far as the currently labor unions have essentially unchecked access to workers' personal information, are you aware of examples where labor unions misuse workers' private information, and how would the Employer Rights Act help to put a stop to this occurring? We got 9 seconds.
Yes, there's been testimony in this committee on unions harassing workers at home, repeatedly coming even after the worker says, please do not come to my house. The Employee Rights Act would protect workers' privacy by giving them the option to choose what piece of personal information to give unions. So, for instance, if they did not want a union coming to their home, they could say, just email me.
Good. Thank you for your testimony. Chairman, I yield back.
Thank you, Mr. Allen. And now we'll go to Representative Jayapal from Washington for 5 minutes.
Thank you, Mr. Chair. Let's just talk about the state of the American workforce under the Biden administration. The administration has created over 14 million jobs, kept unemployment under 4% for the longest time in nearly 50 years, and delivered the most pro-worker agenda in modern history. This year, we've seen a record number of workers standing up against corporate greed to fight for better rights on the job, good benefits, and fair wages. My Republican colleagues are doing everything they can to distract you from those very critical facts on the ground and from the fact that they haven't done anything for workers on this workers or jobs this session. So instead, they're just planning to attack workers' rights. Well, I represent a very strong union town, the third most union-dense state in our country, and we know in our state that unionization is fundamentally about workplace democracy, about the right to organize, and that worker power helps not just workers, but our whole economy. And our state's strong economic status tied to unionization is testament to that. Now, I want to focus on the issue of misclassifying employees as independent contractors. This June, the NLRB issued a pro-worker decision that rightfully reversed a Trump-era policy that allowed companies to misclassify their employees as independent contractors. So let's just get some facts on the table. Mr. Griffin, I want to ask you about specific protections and benefits that are at stake when workers are misclassified as independent contractors instead of employees. So a couple of quick yes/no questions. Are independent contractors guaranteed the minimum wage?
No.
Are independent contractors covered by unemployment insurance?
No.
Are independent contractors covered by family and medical leave?
No.
Are independent contractors covered by health and safety protections?
No.
So tell us briefly what employers stand to gain by intentionally misclassifying workers, and what does it cost Americans in terms of lost wages?
Well, there's been studies, the EPI study that's been before this committee before that talks about the billions of dollars that are lost, not just in wages that ought to be paid to the individual, but in revenues that ought to come to the government pursuant to those the taxes supporting those benefits that you're talking about. So. But the primary thing is that you don't have any rights at all to organize, bargain collectively, and improve your lot.
That's right. So there's an economic benefit, but there's also an overall benefit to what you don't have to provide for workers when they organize. It's clear that misclassifying benefits and intentionally misclassifying their workers as independent contractors allows employers to rob workers of critical benefits and protections that they're entitled to under the National Labor Relations Act. Mr. Griffin, can you elaborate on that?
Yeah, it's very clear the Act has gives rights to employees as defined in the statute, and there is an exception from the employee definition for independent contractors. So if you are an independent contractor, you do not have the rights under the statute.
From the United Auto Workers to Kaiser Healthcare employees to writers and actors, nearly 500,000 workers across America have exercised their right to strike this year. Through their collective power, unionized workers have secured record contracts that have dramatically raised wages and increased benefits, ensuring that workers finally get their fair share of corporate profits, none of which would be possible without the workforce that generates those. Mr. Griffin, since misclassified workers lack protections to organize and strike, what impact would unchecked misclassification have on the labor movement and on the ability of the broader American workforce to secure better pay and benefits?
Well, at least as a legal matter, if you're an independent contractor, as I said before, you're not protected by the rights to act concertedly, form a union, and bargain collectively. And in fact, there are some antitrust questions that arise if real independent contractors, separate businesses get together to collaborate. That raises antitrust concerns. There's a labor exemption to the antitrust laws, and so if you're doing it as an employee, part of a union to achieve certain things, there isn't the same antitrust issue. So people's rights are very much curtailed if they're misclassified.
It is unacceptable that my Republican colleagues want to chip away at these pro-worker policies, and it's our duty to stand with workers who build up our economy. Mr. Chairman, I request unanimous consent to enter into the record a letter from the Child Labor Coalition opposing the Employee Rights Act, the Modern Worker Empowerment Act, and the Save Local Business Act.
Without objection, and the gentlelady's time has expired.
Thank you. I yield back.
We will now recognize Mr. Burleson from Missouri for 5 minutes.
Thank you, Mr. Chairman. Mr. King, it's often been said that workers who are in the right to work states, if they're in a union, that they're probably not happy, or they're less happy. But studies have indicated that actually union labor workers in right to work states are actually, when surveyed, are more satisfied with their job than in the non-right to work states. Have you seen that data?
Yes, I have, Congressman. And just also to build on that point, 94% of the workers in this country that are working under a union contract today never had the opportunity to vote whether they wanted that union to represent them or any union to represent them. And the problem we have here is this hierarchy of control, this confrontation strategy. The UAW strike's been mentioned. It's going to add up to $900 to $1,000 per automobile on the consumer. Ask the question a few years from now whether the American public's going to accept that. So back to your basic question. No, employees want flexibility. They want a right to choose. They don't want to be forced into any particular situation.
And if they're not pleased with the union that's representing them, they have to take drastic steps to remove that union. Unions enjoy a privilege that most businesses don't. They enjoy the privilege of having a monopoly power when it comes to being the bargaining unit.
Well, that's correct. Once a bargaining unit is certified by the National Labor Relations Board, that unit stays in place at that place of business for the life of that business, essentially. So it's a lifetime decision. And the worker, the employee, has no choice. She or he is stuck in that environment. It's not a good situation for anyone. If a union clearly has majority support, so be it. But don't force the decision on the employee.
Mr. Vernuccio, it's often talked about that when you hear the arguments from the other side of the aisle that union workers should be paying the dues because they're being represented. They have, whether it's through bargaining or legal representation. You've heard these arguments before. Do you agree with these arguments?
I do not. It is unfair to force representation on a worker, and it's even more unfair to force that worker to pay for unwanted representation. As Mr. King just pointed out, even in right-to-work states, they are forced to accept union representation, whether they want it or not. Thank you for the question.
Yeah, and if they want to negotiate on their own behalf, they're prohibited from doing that, correct?
Under current law, that is correct.
Okay, which is why I'm filing a bill today called the Workers' Choice Act, and to address this issue, because I think that an individual, in fact, I know a family member who is in this situation that he's in. He's not pleased with his union. He sees people outside of that organization able to negotiate and bargain and get better pay, better conditions, and yet he doesn't have that authority to do that. But this bill will give that worker back the authority.
Mr. Burlington, thank you for the question, and thank you for your leadership on the Workers' Choice Act. That is exactly what it would do. It would give individual workers under a unionized contract in right-to-work states the flexibility to represent themselves, something that over 93% of the rest of private sector workers in the economy can do already if they are not under a unionized workplace.
Yeah, and if this should dispel all the arguments that are said about, the unions have to take the money because they have to represent that individual. Well, if you don't want to represent people that are not paying dues, this is the solution to your complaint.
It's more fair to workers and it's more fair to unions, and I applaud you on your leadership. Thank you.
Thank you. And I'll say in our state, we've seen a diminished number of union representation, but I've seen that because of the economic growth in nearby states, union representation actually goes up even in the right-to-work states.
That is correct. Right to work means unions have to provide better services to their membership to keep that dues money flowing.
Thank you. My time has expired.
Thank you, Mr. Burleson. We'll now recognize Mr. Smucker from Pennsylvania for 5 minutes.
Thank you, Mr. Chairman, for holding this hearing today. And just by way of background, I was a construction company owner for 25 years, non-union, but went through several union organizing campaigns. I am passionate about ensuring that those workers can earn a wage where they can provide for their family and live their own American dream. I think unions have a role to play, but I think workers should have a choice. And too often what I've seen and what you're hearing, I think today, is unions, instead of convincing workers through having better opportunity, you're seeing massive donations going to politicians to try to game the system, to force workers to become part of unions, when most workers today don't want that. And back to that discussion on independent contractors that Ms. Jayapal was talking about, I really think that many folks just would want to do away with independent contractors to force more people into unions. And I know in my area, there are a lot of people who choose to work in that way because they want to be able to negotiate, to do better for themselves, to decide who they want to work for. So the independent contractor, while I agree that it should be well defined. In fact, I was in the state legislature in Pennsylvania, and one of the first things we did, Pennsylvania needed some updated definition to ensure that companies were treating independent contractors and classifying them similarly. So I worked with unions to help to advance a better definition of independent contractor. But we're about a free economy where everyone should have choice. And what I saw in 25 years in the construction industry, there was sort of an inverse relationship with government interference in business, government interference in the economy, over-regulation. We need regulation, but over-regulation and growth, the inverse relationship. The higher the regulation, the harder it is to do business, the harder it is for workers to make decisions for themselves, and the less economic growth and opportunity that we have. I want to talk just a little bit, Mr. Vernuccio. This issue hasn't been brought up here today yet, but that is the update to the Davis-Bacon Act that is being proposed. I've filed a congressional joint resolution of disapproval along with 23 members. Never made sense to me that in all of our free markets, you pick construction, and that is an industry where the wage should be set by the government. Makes no sense whatsoever. And what it does, not only does it's not just about increasing wages, but there's so many more requirements for business. So it completely shuts out some smaller companies, maybe independent contractors who could work in those jobs or bid for those jobs, wherever it may be. So it's certainly a detriment to many smaller companies who aren't able to comply with the regulations. It also increases costs. Just the inefficiencies of that system increases costs. So at a time when we're talking about record deficits, an increase in the Davis-Bacon wages based on faulty promises will increase costs for the taxpayers. Studies show that the rule could increase project costs by as much as 7%, and like I said, it'll stifle competition. So, Mr. Vernuccio, your organization has endorsed this regulation. I'm grateful for that. Could you tell me why this is such a bad idea? Could you talk just a little bit more about that?
Sure, Mr. Smucker, and thank you for your leadership on protecting small business, especially small construction business. Going back to the independent contracting related to the Davis-Bacon rule, there is a good study from the U.S. Chamber of Commerce, the Biden administration whole of government approach to promoting labor unions, and that's where really all of this is coming from. In relation to the Davis-Bacon rule specifically, we do not approve of the regulation. It encourages bad survey data. It eliminates the distinction between rural and urban work. It harms small business. It puts its thumb on the scale for a small minority of construction firms.
Mr. Vernuccio, I'm going to interrupt you. I only have 20 seconds. I just wanted to make one additional point on another issue, and this is in regards to the franchisees. The joint employer rule. I've talked to franchisees in my community who are really concerned about this and are concerned whether they can stay in business in this model. And the question I had, Mr. Howler, for you, and probably won't have time to answer it, but this is going to really impact our communities if franchisees are forced to close as a result of the rule. And we don't know yet exactly what the outcome will be, but it's certainly one of concern. So I'm very concerned about the impact on our local communities and the impact on our workers. And sorry you don't have a chance to respond to that, but thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Smucker. We'll now recognize Mr. Moran from Texas for 5 minutes.
Mr. Haller, I'm going to pick up where Mr. Smucker just left off, and I'm going to give you a chance to answer those questions, because that's exactly what I wanted to talk to you about, was the benefits of the franchise model, what this joint employer rule that's been put in place by the NLRB is going to do to franchises and, frankly, other businesses as well. So let's start generally with the franchise model. Talk about some of the benefits about the franchise model and why folks choose to become franchise owners.
Well, I appreciate the question, Mr. Moran, and thank you also, Mr. Smucker. Not everyone is going to be Elon Musk or Jeff Bezos. Some people may want support and still want to be a small business owner, and that is exactly what the franchise business model does. It allows anyone from anywhere to go into business for themselves, but not by themselves. And the franchisor's job is to give that franchisee the tools and the resources and the support, marketing, and a brand. And in exchange for a fee and an ongoing royalty, the franchisee essentially has a playbook and also a peer network of other franchisees running that same business in their local community. In franchising, generally 94% of the money stays in that local community. Outside of the royalty that's sent back to the franchisor. Franchisor is not in the business of employing the individuals at that business. The franchisee understands the local market. They support local charities and things like that. That is the essence of building the American dream through the franchise model.
Yeah, that you used the term American dream there, and I was going to mention that it really is one of the best ways, a best pathway to the American dream. And a lot of folks access that because they don't have a whole lot of capital up front to invest, to begin their businesses, but through the franchise model, somebody that's already established kind of a way of doing business and has that branding out there can help them get started, and then they can run it locally. And as a result of that, with those local connections, those local work, the local effort and attention, they can become successful business owners in their own right, rather than having to have tons of capital up front. Is that accurate?
That is accurate.
So who are some of the major beneficiaries of the franchise business model?
Well, as I mentioned in my testimony, franchising has greater rates of ownership among women, among veterans, among minorities, among immigrants. It has given this incredible pathway for anybody from anywhere to come to this country or be in this country from an underrepresented community and own and operate a small business by partnering with the right brand.
And those are folks that we want to provide a pathway to ownership in the business world. At least from my perspective, I want to see folks that maybe have had a disadvantaged opportunity in the past to be able to successfully move on and to climb the ladder of success in America and achieve that American dream. And so I think the franchise model is a great way to do that. I note that Oxford Economics released a research on franchising that said that nearly 1/3, 26% of franchises are owned by minorities, compared with 17% of independent businesses. On average, black-owned franchises earn 2.2 times more than black-owned independent businesses. Hispanic-owned franchises earn 1.6 times more than Hispanic-owned independent businesses, and Asian-owned franchises earn 1.4 times more than Asian-owned independent businesses. Those seem like good statistics to me. What do you think?
I would agree those are good statistics, Congressman, and I think, as I mentioned in my testimony, these are all the things that are at risk with respect to this joint employer rule that 800,000 franchise locations are facing in each and every one of your districts.
Yeah, this new joint employer rule by the NLRB starts using what I believe are vague, ambiguous, kind of overly broad terms that are going to effectively make everybody a joint employer in a franchise relationship, and beyond that in a number of other relationships as well. It hurts the independent contractor relationship, certainly, but tell me a little bit about what you see in that joint employer rule that is going to ruin the franchise business model.
Well, it moves the goalposts in the middle of a 10 or 20-year franchise relationship between the brand and the franchisee. And businesses want a bright line test. The NLRB admits this rule will be applied on a case-by-case basis over God knows how long. And the NLRB has proposed a standard based on unexercised control of a non-exclusive list of actions. So as I mentioned in my testimony, I encourage anybody to ask the NLRB, what does this mean?
Yeah, and it's interesting. I was thinking about it yesterday because when one of these factors that may be an indirect control, and we don't even know how expansive that's going to be, or this new set of essential terms and conditions, which now is broader and broader and broader under the NLRB rule, when one of those exists, now the franchisor will be deemed to be the employer of record along with the franchisee. Well, now the franchisor is going to have to exercise broad control over every little detail that goes on, and effectively that relationship is going to be severed between the franchisor and the franchisee, and it's going to be combined.
We call it move over, I'll drive, and that is not why an individual got into the franchise business model.
Yeah, and I think it's contrary to the American dream, contrary to the rules of capitalism, and with that, I would yield back.
Thank you, Mr. Moran, and now we'll recognize the ranking member, Mr. DeSaulnier, for 5 minutes.
Thank you, Mr. Chairman. Excuse me, struggling with a cold. Californian in Washington with the cold weather. I should wear a hat when I go out. I just one comment about where the money goes in campaigns. According to Open Secrets, business entities and wealthy people outspend unions 16-1. So this idea that unions are disproportionately affecting campaigns just is sort of strange. There should be a balance. I don't have a problem with a balance, but that's not the reality. 16-1, and just the Coke network spent $6.5 billion in the last 3 elections, as opposed to the union movement. And that has, to me, a direct correlation line to our income inequality in this country, which isn't good for anybody, including wealthy people. Mr. Griffin, we've heard a lot about flexibility and choice. Maybe you could talk about flexibility and choice if the union movement was weakened or isn't strengthened further. What does a Walmart worker do when they don't have a bargaining unit, as opposed to a Safeway worker or a Costco worker who has a bargaining unit who, granted by a democratic process, has people to bargain for them?
Well, the default option is that the employer dictates the terms and conditions of employment. The fundamental principle under the National Labor Relations Act, which is found in Section 1, is the individual worker is insufficiently powerful to bargain with the large corporate entity to improve his or her terms and conditions of employment. That's why people have to get together, form a union, so that they can jointly work to improve their economic situation, and that the power of the group gets you there. I also, if I may, there's been a discussion about the exclusive representation principle, and I'd point out that This body is a perfect example of the exclusive representation principle. If a Democrat wins an election 52 with 48% of the people voting against them, that 48% of the people who didn't get their choice live with their representative for the next 2 years, and they get another chance. Similarly, there is an opportunity, contrary to what's been said here, every time that a contract comes up, there's an open period during which a decertification petition can be filed and people can have an opportunity to vote. So I want to dispel some representations that have been made here today that don't bear any relation to what the actual law is.
Okay, we've also heard some comments about monopolies in the labor movement. Let's talk a little bit about the balance between global monopolies. Labor unions have to be stronger if they want to. The UAWs showed that and had an impact with auto manufacturers who don't have UAW contracts. Could you talk a little bit about the global economy has been beneficial in some ways, but has clearly concentrated wealth and monopolistic power, and unions have to balance that somehow.
The whole purpose of the National Labor Relations Act, the whole purpose of the labor movement is to improve the lot of working people. And the only way to do that is to be sufficiently powerful to be a counterbalance to the organized power of capital. And so if you have a small labor movement, and the statistics are very clear on that, as the number of organized workers have gone down, the increase in wealth disparity in this country and the concentration of wealth in the top 1% has gone in the other direction. That's irrefutable. And there really is no other force in society that works to distribute the wealth equally among the people who are responsible for producing it.
Yeah, there was a Roosevelt, a Republican Roosevelt, who talked about the malefactors of great wealth. And Franklin Roosevelt obviously was, in spite of some other comments, was a great, both the Roosevelts were great advocates for working people. Mr. Griffith, let's talk a little bit about the PRO Act in the same context of both the previous questions, flexibility and the need to adapt to an employer-employee relationship that's changed because of the concentration of wealth.
Well, I think the PRO Act, one of the issues with respect to the NLRB's ability to enforce the law is that the remedies under the National Labor Relations Act are not sufficiently powerful. And so the PRO Act does a number of things. In particular, it enhances the ability of the board to seek injunctive relief for violations. And so I think the PRO Act would be a very effective piece of legislation in addressing some of the disparities that we see.
Thank you, Mr. Chairman. I yield back with 10 seconds over.
Thank you to our distinguished ranking member. And I now recognize myself for 5 minutes. Mr. Vernuccio, my Small Businesses Before Bureaucrats Act, which I know you're familiar with, and this committee passed yesterday, would update the jurisdictional standards to reflect modern revenue levels and allow these standards to adjust each year with the size of the economy. As you know well, those standards have not been updated since 1958, some 65 years ago. My bill would raise the thresholds to $5 million for retail businesses and $500,000 for non-retail businesses, and those would grow with the economy in subsequent years. Ultimately, this bill would decrease the number of businesses that would fall under the NLRB's jurisdiction and enable them to operate without the threat of the NLRB imposing mandates upon them. It's estimated that about 50% of retail and non-retail businesses would be exempt and relieved from the NLRB's jurisdiction. As you also know, in absence of NLRB jurisdiction, a myriad of laws still cover small businesses and employee relationships, and without the NLRB, employees and employers must work together to resolve any issues relating to compensation, benefits, or safety, and so forth. Would you say that there's been advances and changes in the way that businesses operate in our economy and the workforce since 1958, and maybe we should increase those thresholds?
Mr. Chairman, thank you for the question, and thank you for your leadership, once again, protecting small businesses. I would absolutely say that between the rampant inflation that we're seeing now under Bidenomics and advances in technology and inflation in general, there have been drastic changes since 1958.
Yeah, I would agree with that assessment. Well, given your background with working on and helping employees of all businesses, particularly those small businesses, do you think the NLRB intervention is necessary for the success of a small business?
For the success of a small business, especially those where you're recommending minimums of $5 million in retail, $500,000 in non-retail, those are very small businesses. They would need armies of HR and attorneys to comply with, especially the new and proposed rules coming out of the NLRB, especially from some of the recommendations by the NLRB's general counsel and some of the memos that she has written. So exempting those small businesses would go a long way to alleviating some of that burden.
Thank you. Mr. King, you spoke earlier about how the current president has left vacant the position on the board after the expiration of the Republican member's term from a year ago. What do you think that motivation might be for him to leave that open for a year?
To push the NLRB's very radical agenda that can get cases out faster. They can bypass thoughtful thinking that may not agree with the majority's opinion. And frankly, Mr. Good, the NLRB keeps coming back to the Congress asking for more money. Maybe it's time to put the onus on the administration to say no more money, and indeed maybe less money, unless you equalize the representation of Republicans and Democrats on the board.
Yeah, the NLRB has become a more hyper-partisan organization, I would submit. And what would you say that the impact has been for not having that additional board member, that Republican member?
It has permitted a much more aggressive agenda, a quicker agenda to go through because there's only one Republican to contest some of these very radical theories. And it also has permitted, I would suggest, a very, very radical approach to our labor laws, frankly.
How unusual was it for the president to come in on the first day in office, or one day after he took office, to fire the general counsel, Peter Robb, who still had 11 months left in his term?
That was the first thing this president did. His first official act was to remove the Republican general counsel. That had never happened in the history of the National Labor Relations Act. The bottom line here, the NLRB has become a political arm of the White House. It's not adjudicating matters in a fair and neutral way, and the recent cases certainly support that conclusion.
Yeah, I would agree. Ultimately, Jennifer Abruzzo came to fill the seat. In a Politico article, a former AFL-CIO official said that she is the best general counsel we've seen in a very, very long time. She's trying to make sure that the NLRB takes on the activist role it's supposed to take on. So the president is obviously intentionally, as you noted, using the board as an activist organization to make good on his labor promises, and I would submit that is hurting small businesses and employees across the country. Well, with that, I will go to the ranking member for a closing statement.
Thank you, Mr. Chairman. Mr. King, on one thing I will agree with you. It is unfortunate that we can't get appointees done between the administration and the Senate. And I'll point to the U.S. Supreme Court in the last 20 years where I don't feel like those appointments have been done traditionally. So I would agree with you in that instance. If the environment was better between our parties and our politics in this country, we would go back to an era where there would be respect for procedure and for ideological differences. I do want to, one point as an interesting study from Brookings actually did with a journal about productivity and wages in Republican and Democratic districts and heavy density union ones. And one of the really key things as a former small business person, productivity in dense union districts in Congress from 2008 went from $118,000 per unit to $139,000. This is Brookings in the Wall Street Journal. Whereas opposed in Republican districts that have low union density has stuck at about $110,000. So that we can argue statistics, but there is a good argument as a former small business person who has a cold, that in raising people's wages and benefits. Look at, isn't that nice? The chairman gave me water. Would one of our Democratic staffers test this for me? No, all in good. No. Might be bad for both of us, Bob. Anyways, the context of this, I said in the last hearing, is where do we get this balance between employers and capital and concentration of wealth and workers. And I would argue that unions, as human institutions, are imperfect, just like corporate entities. And right now, that balance is way disproportionate, in my view and perspective. And a lot of it, too, is around employers, whether they're union or non-union, who stick by the rules. And I wish we would get back to that discussion based on rational, not ideological perspective, but as much research and analysis as possible that allows for difference in regions as well as personal experience. In my view, it's absolutely imperative right now that the labor movement, and it's encouraging to see that the Americans have responded in poll after poll, that they don't know the specifics, but they can see how it impacts their disposable income and their ability to educate their kids, have a retirement, and have a house that they can live in and still have discretionary income. And as a former retailer, a point-of-sale retailer, I can tell you when workers make more, employees and small businesses make more. There's more disposable income. We know, whether it's Stiglitz or Piketty, that working people spend more money and put more money into the economy, which benefits the middle class. If you have a lot of money, you tend not to spend as much money in the economy. All of that means that you have to have that countervailing institution that we've known for some time for wages, and that's the American labor movement. So the labor movement is surging, but just as workers have urged their government to protect their rights, committee Democrats have urged the majority in Congress to support the Protecting the Rights to Organize, or the PRO Act, and Theft Prevention, Wage and Recovery Act, and Protecting Children Act, to name a few. This is the kind of legislation that we could negotiate and talk about from our perspective in a healthier institution to benefit everybody and be respectful of, as the chairman and I are both have a background in small business, but we approach this very differently. I think if we looked at those kind of protections, we could do what we just did on the Workforce Investment Recovery Act, that was a compromise and was negotiated in good faith, particularly between the ranking member and the chair, to get a work product that would protect everybody and be more reflective of both of our districts and all of our districts. And with that, I'll yield back.
Thank you, Mr. DeSaulnier. Today we've heard how the NLRB is chipping away at long-standing employee rights that reduce and limit freedom. Republicans are united in fighting for more freedom for Americans, including employees, gig workers, self-employed individuals, and small business owners. We actually believe that the American people are the experts on their vocation, their talents, their finances, and their family. Our laws and regulations are and must be centered on protecting the freedom of choice to work in the profession that Americans are called to, under the terms they choose to freely and independently build their lives. These principles are the underpinning of the American dream, and we must fight to preserve them. The alternate ideology suggests that employees are too dumb to know what they want, and they need government to take care of them, because all employers wake up in the morning seeking to abuse and exploit their employees. But Americans don't want or need the federal government giving them advice on how a business should operate. And I appreciate what Mr. Howler said earlier, that only 14% of franchisees would open a business if the joint employer rule was in effect. What a sobering statistic. Mr. King also noted that the NLRB has reversed precedent in nearly 5,000 cases recently and overturned 100 years of precedents, making it nearly impossible for employers to comply and to know how to operate their business under this biased, hyper-radical NLRB. Under the Biden administration, the NLRB has damaged its reputation as independent and neutral. And again, I appreciate the recommendation that Mr. King made of a policy change that a departing member from the board should continue to serve until they're replaced, so that we wouldn't suffer under the shortage that we suffer under today. The General Counsel of the NLRB, Ms. Abruzzo, has made no effort to hide her extreme pro-union agenda, and she's undermined the National Labor Relations Act in the process. I will repeat the quote that I said earlier from the AFL-CIO political director, who said she's the best general counsel we've seen in a very, very long time. She's trying to make sure that the NLRB takes on the activist role it's supposed to take on. After hearing the accounts today, I hope we can move forward with the legislative ideas that reduce invasive government overreach in the NLRB and further diminish harmful union influence and facilitate employee privacy and choice. I ask unanimous consent to submit the following letters of support into the record from the Intermodal Association of North America, Americans for Prosperity, American Hotel Lodging Association, Associated Builders and Contractors, Flex, TechNet, the National Retail Federation, and a letter from the Coalition for a Democratic Workplace that 72 organizations from various industries signed on to. So without objection, that is so ordered. Without objection, there being no further business, the committee stands adjourned.